Hi, it's Bill. I practice divorce and family law at the Gentry Law Firm in Marietta. This is another in our series of Lunch and Learn webinars about divorce and family law. Afterwards, we'll be posting this webinar on our YouTube channel, Gentry Law Firm, LLC. At the end of our presentation, you can post your questions in the chat box. Today, we're going to speak with two great divorce and family law mediators, Jim Holmes and Cindie Alter. Welcome, Cindie and Jim.
Thank you for having me, Bill.
Thank you, Bill. Good afternoon.
Jim, can you tell our audience a little bit about your background?
Well, Bill, I grew up in Moultrie, Georgia, of all places, and then went to Emory for 4 years. And then my draft board said, Jim, you're a 1A. So after spending almost 5 years on destroyers, and particularly the North Atlantic and Med, I came out and went to law school and graduate business school at Virginia. Started practicing law in 1978, and I tell people for about 25, almost 30 years, I had a divorce practice. I did family law, and I also did business divorces, sub-S's and partnerships breaking up. And then in 1997, when I came back from a deployment, I started doing mediations, and it gradually just took over so that I'm not doing much litigation anymore and do primarily mediations and arbitrations.
Excellent. What led you to become a mediator?
One, I needed different avenues to start earning money. I had been deployed for 331 days and my law practice had been shut down, so that was a good avenue. It was also my thinking that by mediating, I could better familiarize myself with attorneys' philosophies of what they thought was good and bad, right and wrong in family law cases. And third, I was hoping it would be a better way to settle a divorce than mine was settled. It took me 2.5 years to get divorced, and we settled at the courthouse as they were calling jurors in to try our case. So I was hoping we could find a different avenue, and it's worked out that way. It's been very beneficial to me, and I hope to the people I mediate with.
Good. I bet you've done a lot of mediations over the years.
I have never counted. I estimated at least 2,500, 3,000, maybe more, but I've just never counted, Bill.
Okay, and those are mainly family law mediations.
About 85% is family law. The other has been some probate, some personal injury, some business disputes, but about 85% is family law. Yes, sir.
Well, Cindie, tell us about yourself, your background.
Well, I came to Atlanta to go to Emory Law School, graduated in 1978, and had a general litigation practice until the end of 1989. At that point, I took a break. I took a hiatus from the legal profession to raise my 2 children, and I did that throughout the 90s. I returned to the profession in 2001, and I took a job in Cobb County Superior Court as a staff attorney for the late Ken Nix. I returned to private practice at the beginning of 2009, mediating and litigating, but my mediation practice became so busy that it literally forced me to stop litigating, and I'm now only mediating and doing a little bit of guardian ad litem work.
So you've been mediating for how long?
I became registered as a mediator in 2006 and an arbitrator in 2007. And actually, interestingly enough, I didn't consciously ever set out to be a mediator. When I was working for Judge Nix, at that point, there was no family law workshop, and the pro se litigants really didn't know how to navigate the system. So the judge would send me out to the jury room with the unrepresented litigants to help them resolve the cases. And I originally just took the mediation training so I'd be better prepared for that task. And then once I started mediating, I came to realize just how much my professional and my personal life would assist me in being successful as a mediator. There's no place in the courtroom I haven't sat. I've been a litigator representing both husbands and wives, mothers and fathers, obviously. I have been a litigant in a lengthy, like Jim, time-consuming and very costly case. And when I was working for Judge Nix, I sat in front of him in the courtroom for every single domestic case, and I was involved in every decision he made. So when I'm at the mediation table, I know exactly how the parties feel, and I know all too well the emotional toll that litigation can have.
Well, so any idea how many mediations you've handled over the years?
Well, like Jim, I hadn't really, until we were preparing for this, I hadn't really thought about it, but I actually did the math, and I've probably done between 2,000 and 3,000. And like Jim also, mostly family law, few probate, few personal, few business splits, which are a lot like divorces, but I'd say 90% are probably family law cases.
Right. Well, the vast majority of divorce and family law cases do end up settling, at least in my experience. And settlement can happen through discussions between the parties or their lawyers. But if the case can't be settled this way, most judges in Metro Atlanta require the parties to try to settle their cases through mediation before the judges will let them schedule a contested final trial. So Cindie, what is mediation and how do you conduct it as a mediator?
Mediation is a self-directed, voluntary process where the parties have an opportunity to resolve their case without costly, prolonged litigation, and literally without a judge telling them how to parent their child or children, divide their assets, debts, and income. Though, as you said, Bill, most mediations are in fact court-ordered, thus attendance is mandatory. The rest really is voluntary. You're court-ordered to appear, you're court-ordered to mediate in good faith, you're not court-ordered to settle, and you waive none of your rights to access to the court system by participating in mediation. Although I could probably spend the entire webinar talking about why it's better to settle in mediation than litigation. While we're all bound by confidentiality and specific guidelines, that's where I like the formality to end. When I do a mediation, no two unfold exactly alike. I take my cues from the lawyers and the parties, and I do my best to stay within everyone's comfort zone. While I prefer at the beginning to have everybody in the same room long enough for me to at least explain the mediation process and go over the guidelines, I check with everyone first to make sure that all concerned are comfortable with that. If so, we meet together to discuss what mediation is about, and then we break into private session, which we call caucus. If either party is the least bit uncomfortable being in the same room with the other party, then we immediately break into caucus, and the entire mediation will usually unfold in two separate rooms. I generally meet with the plaintiff, the moving party first, unless the lawyers tell me to proceed otherwise. And unlike arbitrators, the mediators do not make any decisions in the case. The parties do the decision-making with the guidance of their lawyers. But I do try to help the parties think outside of the box and come up with creative solutions. I also usually do not start with an attorney meeting first unless there's a guardian ad litem involved in the case. And if the guardian hasn't had ample opportunity to bring the lawyers up to speed, just in the interest in time and efficiency, I will have an attorney meeting to meet with the guardian and the lawyers and allow the guardian to bring the lawyers up to speed.
Well, Jim, how do you handle mediations when you're the mediator?
Well, we're a little bit different, Cindie and I. As she said, our job is not to be a strong man, strong woman and impose settlement. Our job as the mediator is simply to give the parties the chance to let the process work and see if they can come up with their own resolution. Picking up on what Cindie said about confidentiality and going a little bit further, any offer made at mediation is not admissible into court. It's dead if you don't settle the case. The judge is not entitled to hear about those offers. And that's why you try to make people feel comfortable, as Cindie said, and feel comfortable about making an offer knowing that it won't be thrown back in their face if they get put on the witness stand. Unlike Cindie, I like to meet with the lawyers first. Now, when I went through mediation training, the first thing they told me is don't let the lawyers talk, but I do. And I do that for primarily two reasons. It gets me in the ballpark quicker, and they know the case, and they can direct me, if you will, just as Cindie implied, as to whether I meet with the plaintiff or defendant. That meeting is not intended for attorneys to have to lay their cards on the table, although I have been told recently that some attorneys feel like they need to do that. But I do like to meet with the attorneys first. Then I go into the private session of the caucus. And this is where I think you earn your keep as a mediator, because as Cindie said, you have to read the vibes in the room. You have to read the parties. You have to read the lawyers. And going back to not let lawyers talk, I'll listen to the lawyer, but I really want to hear from the party. They need to take charge. They need to be in control, and they need to try to settle their case. And You just have to be very, very sensitive to each room, each different room, each lawyer style, and also what's going on in the party's life. That's the way I generally do it, Bill.
Well, Jim, you talked about caucus, and caucus is where you meet privately with the one side and their lawyer, or the other side and their lawyer, but not everybody together, right?
That's correct. Thank you for clarifying that. That's correct.
That's fine.
I think you've done that before, haven't you, Bill?
Just a couple times. Well, I haven't done as many mediations as you guys have. I mean, you're together up around the 5,000 range. I probably am, I don't know, 300 or 400 at this point, but plenty. Well, Jim, over the last few months, we've been socially isolating, socially distancing because of COVID. And so a lot of lawyers, including and you guys as mediators, have moved to virtual mediations through Zoom and similar platforms. So Jim, tell us about your experience with virtual mediations in the last few months.
Well, it's been a necessity to do any work at all, quite candidly. I had to learn it, and I am not technically proficient. Fortunately, I had some friends that spent a couple hours just sitting in front of the computer, and I can't tell you how many tutorials I looked on the Zoom website to figure out how all this is done. And it's something to be considered moving forward after we break out, Bill, especially for parties that are geographically unavailable or ill or something like that and can't come to the geographical site of the mediation. However, I don't like it. It's not my preference. Again, both Cindie and I have talked about the vibes in the room, what's going on with the parties, what's going on with the attorneys. You can't get that sense over Zoom. Also, I've done Zooms where the internet connection was lost, so then we had to go to a telephone conference. And oh, by the way, kids walk into the room of the parties, the dogs are barking, there are all kinds of distractions going on. So while it's an alternative, it ain't my preference.
Well, I know we probably all at this point seen or heard about that, the jury trial they had going on out in Texas, where by Zoom, and in the middle of the parties presenting their case, one of the jurors stood up, put his phone to his ear, and walked out of the room. So of course they had to stop the trial. But what you're saying is there are plenty of distractions when you're doing it by Zoom versus being in a central location.
Absolutely, absolutely.
Well, Cindie, what about you? What's been your experience with Zoom mediations? I assume you've done a number of them over the last couple of months.
Absolutely. So at first, like anything else new, and I too, like Jim, had to learn the technology. There were no computers when I went to law school. So I was hoping to be able to retire before I had to learn all this, but be that as it may, we are where we are. But at first, like anything else new, it was not a preferred method by me or the lawyers that I litigate for. When the courts abruptly shut down, most of my mediations just out and out canceled or were postponed. I guess at that point, we were also overwhelmed by what was happening that we really didn't process how long the pandemic would last. And once everyone started realizing that this could be a new normal, I started doing more and more Zoom mediations. And now my calendar's booked up. I think I've got one every single day to the end of June. And like Jim, it's not my preferred method. I am a people person. I love being with people, and I really miss the personal contact. You know, appropriate or not, many times at the end of very lengthy mediation, the litigants would ask if they could hug me, and you just don't get that in a Zoom. And like Jim said, you really need to be able to observe the body language, and sometimes the body language assists in assessing a person's feelings and thus their needs relative to the outcome. And again, like Jim, it's difficult to control the environment. Laying on your bed or being in a moving car, both of which I've had happen, is not really the best way to be negotiating a settlement that could really affect the rest of your lives, or at least the immediate future. Yeah. But all things considered, it is a viable alternative, and I foresee it being used in a number of cases, even when this pandemic is over. Yep. Now, one of the upsides of using Zoom is that even though the application allows for document exchange, it's clearly not the same as handing documents, in person in a mediation. So I invite litigants, lawyers, anybody to send me documents ahead of time. And if they send them to me, I read them and I walk in, way ahead of the game.
Absolutely.
Because even if I've just read the pleadings, I know what we're there for. Otherwise, I used to walk in cold. I don't know if it's a modification, a legitimation, or a divorce. So there is some good things to it.
Yeah, and Bill, I think it can be used, for arbitrations, for late case evaluations, but again, for the same reasons, but it's just not the desired mode to do this kind of work.
Understood. Well, Cindie, let's talk about your best practices for lawyers and litigants or parties preparing for and going through mediation.
Okay, I'm going to actually list this in a laundry list. First of all, this is addressed to the lawyers. First, be prepared. Walk into mediation with a knowledge of your case as if it was a trial. Make sure your clients have provided you all the financial information and have updated it as close to mediation as is possible, assets as well as debts. Update the domestic relations financial affidavits and child support worksheets prior to mediation as required by the Uniform Superior Court rules.
And that's important. It is required that they do that.
And I find in many mediations, they don't, and it
Right.
becomes a bone of contention, and we waste time arguing about that. So if that's done in advance and we've got updated, it just makes the mediation quicker. Also, if there's a separate property claim, which a lot of times there is, make sure your clients provide the documents to support that claim. You just can't walk in and say, this is mine, without proof. The other lawyer's just not going to accept it. If one side wants to retain the marital residence, it's also massively helpful to have something other than Zillow and the property tax records to determine the fair market value. It's helpful also if one party has reached out to a lender to determine the feasibility of a finance. The smoothest I've ever had happen when property was at issue is somebody knew they were pre-qualified, they could get that loan in 30, 60 days, and we could go from there. If children are involved, come into mediation with a draft of a parenting plan that preferably your client has reviewed and approved. And make sure your clients have realistic expectations. That's to the lawyers. Now to the litigants.
Wow.
Know what you want. If you need spousal support, know within a range how much you'll need and for how long you're going to need it to get back on your feet. Have a plan. Especially if there's children, you need a parenting plan. It's helpful to know where you will be living in relation to the other parent, as the location subsequent to the litigation has a huge bearing on parenting time for the secondary custodial parent. Also, while this is a very emotional and challenging time in the litigant's life, try to keep in mind that if you don't settle in mediation, the judge is not going to have the same emotional investment in your case as you do. Always remember that your case is factually different from your friends and from cases you've read on the internet, and do not expect the same outcome as other people. And lastly, just like to the lawyers, have realistic expectations.
Well, Jim, you had talked earlier about letting the process work, which is very important. So do you have some best practices or some tips or some ideas that lawyers and litigants should keep in mind? I know Cindie had a very thorough and exhaustive list, but what's your take on that situation?
Yeah, I was fixing to say, just replay Cindie out on YouTube and you got it.
Sorry.
No, I would summarize what Cindie said in this: do your homework, and do your homework intensely and realistically. Cindie also said realistic expectations. Lawyers sometimes don't realize that their clients' expectations change over time and they need to be governed. And that's why you need to meet with your client shortly before the mediation and see what in the heck's going on in their lives. I've had people come to mediation and the lawyer says, well, you're still paying for that car. No, I sold that car. Or you're still living in this house. Well, I'm renting a, so you need to get the lawyer the current facts. But a lawyer is only as good as their client on this stuff, Bill, and it's really imperative that the parties do their homework with guidance from the lawyer or the lawyer's office. Cindie mentioned more than Zillow. Yeah, you may not have to get an appraisal, but at least get a market analysis. There's also Zillow, Redfin, and probably 4 or 5 other real estate sites that you could at least come up with an average. It's kind of like going to Kelley Blue Book and all the others for a car, but at least you can get in the ballpark as to what the value is. No, it's just a lot of details. I have people come and they don't even know what school district they're going to be living in or how far the parties are going to be living apart. And it's hard to get this information at the mediation. Thank gosh we got the internet now, but it's just very, very imperative that the homework is done. And then both the lawyer and the client are on the same page on this. What are the must-haves and what are the nice-to-haves? In other words, what do I absolutely have to have if I settle this case? And what would be kind of the icing on the cake? And the lawyers and the clients need to be on the same page on that.
All right. Well, I know, Jim, you have talked about getting this information in advance, and it sounds like both of you are saying prepare. Have the client prepare, you be prepared, meet with the client before the mediation. I think we've all seen situations where the lawyer didn't even know the client, didn't really know because their paralegal or someone else in their office have been doing all of the preparatory work, and the lawyer didn't have any kind of a bond or relationship. And so when they walked into mediation, you know, kind of along those lines, Jim, do you have any particular do's and don'ts for mediation?
I don't impose settlement. I have adjourned mediations because I felt like the party was uncomfortable even though we were almost at settlement. I don't have a practice of getting people to sign things knowing that the minute they walk out your office's front door, they're not going to like it. I do try to make sure the lawyers don't impose settlement, that this is something the client wants to do. And I specifically try to ask the client now, is this okay with you? And does this cover all the issues? But other than that, I go with my gut a lot, Bill. You know, what's the process going to help these people do their job? As Cindie said, they're going to do a better job than the judge will ever do. Not because we don't have smart judges, but the judges don't have time. They don't bring the emotional background and baggage to the case, and they will not learn and know the case as much as you want the judge to learn and know the case. I mean, what's the old adage? And these numbers are probably off, but a judge remembers, hears 2/3 of what you say, remember half of that, and can apply half of that. So, I mean, you're getting down to a very small percentage of where the judge is in his or her understanding of the case when it comes to entering an order. So take advantage of the process. And then one more thing, and I'll shut up. When I was litigating, I liked the clients to do the homework as much as possible so that they could stand up for themselves and also so they could learn it. So if they have to get up on the witness stand, they know what in the heck to say.
Right, right. Well, Cindie and Jim, I know you both have served as guardians ad litem, and I don't want to go off too much on a tangent in that regard, but how valuable they can be. And Cindie, I think both of y'all had mentioned when guardians are in mediation, that they can be a real plus when they share the results of their report. And then arbitration. I know, Cindie, you handle arbitrations. Jim, do you do any arbitrations as well?
Do a lot, particularly on personal property stuff, but I've done some other business arbitrations as well.
And just to clarify for the viewers, an arbitration differs from a mediation because a mediation is you don't have to settle, but an arbitration is where you're sitting there basically as the judge, right?
That's correct. That's correct.
And I actually foresee a lot more arbitrations in the immediate future once the courthouses reopen, because I think the judges are going to be so slammed and so far behind that if people can't settle at mediation, arbitration may be a feasible alternative to not wait a year to get your day in court.
Yeah. Well, you anticipated my next question, which is that's exactly what's going on, because mediations to a certain extent have slowed down. And then the courts have all but stopped hearing things other than some criminal cases, and they're just starting to open back up. So give me your thoughts on that, Cindie.
Well, my personal thought, and I don't know this, I haven't talked to judges, once the courts open back up, it sounds from the information I've been getting that the public access is going to be limited. There was actually an email or something I got from Cobb County within the last couple of days. They're going to have each judge is going to have one domestic case per week, and they're going to try to address everything. But my sense is they're going to have to deal with the criminal stuff first, and they're going to have to deal with domestic violence cases first. And my just personal feelings is the regular civil cases are not going to be real high on the list of priorities as far as getting into the courtroom once this is over. And I don't think there's going to be an end in sight as quickly as we would all like this pandemic to be over.
Well, and by regular civil cases, that includes divorces, legitimations, custody changes, child support changes, and so forth. Well, Jim, any closing thoughts for our viewers? We're getting about 25 minutes, so we need to kind of start wrapping it up.
No, I would just encourage each party to realize that it is far, far better to settle your case than to have a judge, or in divorce cases, you have a right to a jury trial, do it for you. It's just, it saves money and it saves emotional energy. And I'm going to say it saves emotional energy, and it gets it done quicker. So I encourage you to think about it. You're not required to settle. Some cases don't settle, but it is a real positive alternative if you can do it for yourself and if there are children involved for the kids.
Very good. Cindie, any final closing words for us?
Yes, when I was litigating, I used to tell my clients, and this was before we had a state lottery, the only form of legalized gambling is walking into that courtroom. As lawyers, we think within parameters, we know what a judge is going to do, but we do not know until it's over. It is a crapshoot. Mediation, however, provides certainty of outcome as well as finality. And lastly, judges tend to paint with a really broad brush. One of our judges in Cobb County said to a client of mine when we were litigating, your lawyers will edit each other's parenting plans with a scalpel. If I have to make the decision, I'll use a hatchet. We did not settle the case, and he was true to his word. He used a hatchet. There were things in the parenting plan each party wanted that were not in there. You'll get a much more detailed, well thought out document if you settle the case either through your attorneys or in mediation.
I completely agree, Bill.
Very good. Well, you can reach us at the Gentry Law Firm by phone at 770-425-5573, by email at info@gentrylawfirm.law, and through our website at gentrylawfirmgeorgia.com. Please like and follow our firm on Facebook, Twitter, Instagram, YouTube, and LinkedIn for more updates. And please share this video with anyone who may need it. All right, this time we'll wrap up. Thanks so much, Cindie Alter, Jim Holmes, great mediators. Thank you again. And that concludes our presentation.
Thank you, Bill.
Thank you, Bill.
Bye-bye.